this. We're going forward and backward. Okay.
Yeah, you just
Okay.
kind of announce yourself. Right?
Okay. Good morning, everyone. Can everyone hear me okay? No? Okay. Okay. Apparently, I'm supposed to attach this, but I have nowhere to attach it to, so I don't have a pocket, so it's okay. I'll just hold this. Is that better, everyone? Okay. Well, I want to welcome everyone to the gun law seminar. My name is Mary Beth Parilla, and I want to tell you a little bit about me. I like to call myself an anomaly. It's, as Steve mentioned last week in Charleston, I am the first female to present at the gun law seminar. And what makes it more of an anomaly is having a woman in this world, but also in the world of gun law, but also I grew up in the People's Republic of New Jersey. So those two things together, when I first started practicing in South Carolina, judges couldn't figure it out. It was, we don't get it. You're a Yankee and you're a female. How does that happen? Give you a little bit about how it happened is that my father's family comes from Ukraine. So there is a strong Eastern European influence there about being proponents of gun owners. And also raised me to basically had a bunch of friends that were in law enforcement. And they were talking and said, how do you make sure that your daughter is not a victim of domestic violence? How do you teach your daughter to protect herself? And consequently, it was teach your daughter to shoot. We all know about cases, a lot of highly publicized cases. Is that echoing back there? Okay, I'm sorry, I feel like it's echoing. A lot of highly publicized cases of females, and let's face it, the reality is, no matter how tough we want to think that we are, we're no match for a 300, 400-pound guy. I don't know if anybody remembers a case about 2 years ago that made national news of the home invasion of the woman that was home with her child, and guy broke into the home and was beating her. When that case came on the national news, my brother called me that night and said, hey, I know that guy, that's Sean Custis. I went to college with him. He said, I remember him from weightlifting in the gym. He on a routine basis can lift 350, 400 pounds. So it doesn't matter how strong we are, how many self-defense classes we take. The reality is we're not going to be able to match up. So that kind of sparked my interest in firearms law, firearms ownership. I do shoot. I like to do trap shooting. And when I was in law school, there was a scholarship program offered. I was in my second year of law school. And it was interesting to me that, as you can see from the slide, I went to Western Michigan Thomas Cooley School of Law in Lansing, Michigan. Nobody had a Second Amendment class. When I got to con law, I wondered why doesn't anybody, we touched the first, we touched the fourth, we spent a good deal on the fourth, fifth, 14th. Nobody touches the Second Amendment. So I did an independent study where I went through and basically researched kind of what I kind of had in the back of my head, and was I confirming what I was led to believe with the Second Amendment? And this all happened prior to the Heller case coming out. So I researched that for about 6 months and ended up getting class credit for that, but I actually won second place through the NRA scholarship contest for that paper, which has subsequently been published by Florida A&M. I do work for the NRA. I am not an NRA attorney. I am a private practitioner. However, I do routinely consult with them, and if somebody is involved in a self-defense shooting in the upstate, I am the person on this part of the state that would work with the Office of General Counsel. I have had cases that they have funded, and essentially, if you're in a position where you've got somebody that comes into your office that has a legitimate Second Amendment case that they can't afford, the NRA's Office of Civil Rights Defense Fund actually has money set aside for cases that they think are timely and worth investing in. So that's something that you need to know, that if you want to take on a case, some of that is available to you. And at the end, I'll give you my email address. If anybody's interested in having my PowerPoint email to them, just shoot me an email and I'll send it out to you. I didn't duplicate these today. Okay. What we're here for today, the part of this program that I'm going to talk about is tying together the new domestic violence law, the Domestic Violence Reform Act, guns, and family law. Routinely, I practice in family court. I am a defense attorney. So I will try to not be slated too much from a defense perspective, but understand that that's where I'm coming from. And I kind of like defense better just simply because it allows me to go through and look at everybody else's mistakes. Makes practicing a little bit easier. But the long and the short is South Carolina doesn't have a great track record when it comes to domestic violence. According to the Violence Policy Center, we are first in domestic violence against women, and we have been in the top 10 for the last 18 years. So clearly, as a woman, I'm not advocating in any way, shape, or form abuse, but I think it's important as a practitioner to understand what really is abuse versus what is alleged to be abuse. And that's some of the concern that I'll get to in a little bit. By show of hands, does anybody in here practice in family court? Okay, so a few of you. Anybody handle DSS cases? Gentleman in the back can put his hand down. Okay. I have done that. I've been on the defense side practicing with the DSS cases for the last 7 years. And I have seen cases where the easiest way to get to somebody is basically launch an allegation of domestic violence or sexual abuse. I'm not going to get into sexual abuse today, but those are the two easiest ways in family court because the burden in family court is so different. You don't have to prove that case beyond a reasonable doubt. You only have to prove it by a preponderance of the evidence in most cases. So in response to our horrible record of domestic violence in the state, Governor Haley signed the Domestic Violence Reform Act in June. And, you know, it's a relatively new law. I'm sure things are going to play out. But the goal of the law is essentially to create the degrees of domestic violence. So we've now broken that. And following me, Henry is going to give you a little bit more background, the next presenter, on specifics of the law and getting a little bit more detail into the different code sections. But there are now degrees set up. It has an effect on the bond hearings. And what we're here for today is the effect on firearms ownership. Part of the Domestic Violence Reform Act is limiting, it has implications on your firearms ownership. I think most people in this room probably know that if you have a domestic violence conviction, you will be a prohibited person under 18 U.S.C. 922G. That's the federal prohibition. But we are really getting things stricter about this. The Act asks the solicitors in their discretion to create essentially something like PTI for misdemeanors, and also directing DSS to become involved. And as a defense attorney, this is where I have some level of concern because I think the law itself needs to be very specific about what domestic violence is and what it is not. And I'm going to get into the Castleman case in a little bit. I don't know if anyone's familiar with that. But essentially, the Castleman case is, I'm going to go back to this. The Castleman case is a 2014 Supreme Court case that basically distinguishes between physical force and violent force. And I guess, by a show of hands, how many people think squirting somebody with a water gun is domestic violence? No one. Guess what? Under Castleman it is. There is a case out of Florida in 2013 that woman had a boyfriend that was on an Xbox. He would not get off the Xbox. She squirted him with a water gun. And Castleman gives us a new definition that any offensive touching is now domestic violence. The threshold is really low. And I think anyone that owns a firearm really needs to be concerned about that. I think you're going to have a lot more people walking into your offices with complaints about this. When we deal with cases in the DSS world, we're not always dealing with the most stable people. I would say 95% of my clients have either some form of mental health issue or drug issue or a combination of both. So it doesn't take much for somebody to pick up the phone and you are now a domestic abuser, or at least an alleged domestic abuser. Okay. In Castleman, he was charged with, in 2001, intentionally and knowingly causing bodily injury to the mother of his child. Okay. He argued that his conviction did not qualify for the intentionally knowing and causing bodily injury because it didn't involve the use or attempted use of physical force. The court agreed that physical force has to entail violent contact and that you can cause bodily injury without violent contact. And they give an example of poisoning somebody. That would clearly be a domestic violence situation. But the court has basically said that, and here's where we get into the physical force requirement, it's satisfied by anything that would support a common law battery conviction. So there's our low threshold. Now, in the world of family court, if you go, the allegations made, you're convicted. Now, as part of the governor's domestic violence task force, they've encouraged DSS to become involved in your life. How many people in the room have handled a DSS case? Okay, so everybody prior to the 608 contracts, y'all have been stuck with them before, whether you're family law practitioners or not. And so, once you're in that world, you've got somebody that walks in, they've got a criminal problem. They now have DSS involved in their life. And once DSS steps in, the law enforcement can report it, they don't have to. So one of the things that I think is encouraging about the law is it does give law enforcement some discretion about whether or not they want to pursue it. One thing about the domestic violence also is that it requires, starting the school year 2016-2017, so it'll go into effect in the fall, domestic violence to start being taught to students between, I believe it was 6th to 8th grade. That's got to be a mandatory component as part of the health class. So the component to that, or I guess the implication to that, is if a child goes to school, we all know that teachers are mandatory reporters. If a child goes to school and says mom and dad are fighting or arguing, you've got a mandatory reporter. I see a lot in my practice with domestic violence cases in DSS where the child has never been harmed. The child has actually not been touched at all. And the allegation in the initial investigation is the child could have been. They ask for a finding of substantial risk of physical abuse because mom and dad were arguing. Now, by show of hands, I'm going to keep you awake one way or another. By show of hands, how many have been married more than 20 years? Okay. How many will admit to having an argument that has escalated, not necessarily touching anybody, but under the new standard could have been qualified as a domestic violence offense? And again, I got one. All right, I give you a lot of credit for at least being honest. Again, my heritage is Ukrainian, my husband is Latino. When we argue, we don't argue frequently, but we argue. And again, growing up in New Jersey, pretty much every argument in a household up there could qualify under this new domestic violence law. So it's a concern. Most people won't up to it. I will, okay? So there is, and I'll come back to this, but there is a recourse for bad faith if somebody launches an allegation that turns out to not be true. You can ask for damages, punitives, and attorney's fees and costs. But once DSS gets wind of an allegation, you now have an emergency protective custody hearing or situation. They can come in and take the child without, basically once they determine, if law enforcement determines in their discretion that there's probable cause to take the child into custody, they can. And at that point, DSS has 24 hours to start their preliminary investigation. Okay? What I want you to do is kind of cognizantly keep track of the number of days that can pass here. So they, under 63-7-660, they can assume legal custody. Okay. Then we have to have a probable cause hearing within 72 hours. So we've got 3 days later. Your child is still in DSS custody. And you have to have a merits hearing within 35 days. How many people are from Greenville? Okay. Typically, I practice primarily in Spartanburg and Anderson counties. Spartanburg is one of the busiest, if not the busiest, county in the state for DSS cases. It is not infrequent for merits hearings to be continued for good cause beyond 35 days. One of the reasons for that is lack of court time. So if a trial, what'll happen is when you get for the first call merits hearing, if you have an agreement, great, the court will entertain that agreement that day and allow you to put the agreement on the record. If you want to have a contested hearing, you've got to set that for a trial. And I've seen situations, depending on how many parties are involved, and when I say that, keep in mind that not all of the children that are involved in these cases have the same father. So you can have 4 or 5 different attorneys as part of one case involved in these things. 2 months can sometimes happen. I mean, the courts make every effort to try to get them in as close to 35 days as possible. But again, you had 3 days before, you've got 35. Let's just conservatively say, okay, you're at 38 days at this point. Then you have your trial. If you are ordered a treatment plan, the child is not going to be returned home until you complete the treatment plan. The part that concerns me as a defense attorney is what constitutes compliance with the treatment plan. And a typical plan includes drug testing, pretty much for everybody. That can be done more than once. Parenting classes are typically running 6 weeks. An anger management class typically runs 26 weeks. Okay, so just add that up to the 38 days that we already have. Then if they ask you to do therapy, which is, again, very common because the DSS, again, in the best interest of the child, wants to make sure the home is stable to return the child to, but you will be in therapy until the therapist determines that you're good to go. So we don't really have a closed time frame here to figure out when this is going to end. Depending on who's handling the case and how your client responds. And these two I want to get into, because clearly the majority of people are going to be upset and depressed if your child has been taken out of your home. But if you react to that a little bit too much, you're going to be asked to go for a mental health evaluation to see if you need medication and have you assessed for depression. That in and of itself has an implication with firearms law down the road. Under the new executive orders that are being pushed, we're concerned about people's mental health. And I don't know that anybody has defined exactly where that line's going to be drawn of what is a mental health problem. My understanding is right now we still want an adjudication, but what concerns me is a request that if doctors are forced to report, I don't know that anybody has defined in there if you're a threat to yourself or others, and that leaves the door open for some issues here. If the person is too emotional, they're going to send them for a psychological evaluation. And in that case, you can wait 3 months for an appointment for a psychological evaluation. Then you can also wait about 6 weeks for the report to come back. So the days are adding up. In the meantime, your child is still in the state custody. You're going to get put under child support order, and then everybody's going to come out and check out your housing. Now, in certain situations, obviously, nobody wants to return a child home to a domestic abuse situation. They're going to want one of the parties to leave. And at least in my caseload, that sometimes causes a problem because people will come back and say, hey, we've gone through the counseling, we want to stay together, we've done everything we wanted. And that, in and of itself, creates an issue because you can... At that point, if you believe you've completed your treatment plan and DSS does not, then you've got to have a contested hearing for that. And again, we're into the issue of our courts and how much time everybody has allotted for scheduling of trials. When your child is in care, you're going to get your standard visitation at DSS once a week. It'll be monitored, and you're going to have a guardian ad litem involved. Now, the complicating factor, and I'm going to try to rush through this a little bit because I know Henry's going to come up after, but if your client is facing criminal charges in connection with the domestic violence, because of the burden of proof and because of the risk of exposing your client to testimony that could be used against them in a criminal trial, you're going to be looking likely at an Alford plea. If you allow them to testify, anything they say is going to be used against them in that trial. I was in a case yesterday, and the solicitor was sitting in the back of the courtroom to see if the defendant was going to testify in the family court case. So the problem as a defense attorney that creates is you're trying a family court case with your hands tied behind your back. You're exposing your client to risk of imprisonment if you let them testify. So in a lot of cases, DSS is getting agreements on cases simply because people can't defend themselves here. You can defend it, they have every right to defend it, but there's a big risk to doing it. So again, based on the difference of burden of proof. In a domestic violence situation, and again, it depends on what county you're in. There is some difference in various counties, but in most cases, they are looking for an entry into the Central Registry of Abuse and Neglect. And if that happens, your client cannot get a job in a nursing home. They can't get a job in a daycare center. They can't volunteer to coach. So there's a lot of implications to this. Okay. Depending on the progress, and this actually I should have had this in the prior slides, but depending on your client's progress, there are permanency planning hearings there about whether DSS believes that adequate progress is being made in a timely manner, and a permanency planning hearing only has to be held within a year. So there are judicial reviews at various times. So there's a lot there. My time is almost up. Does anybody have any questions before I turn it over to Henry? Okay, I'm going to give you my email address, and I'm going to go back to the first slide to do that. My last name has 2 R's and 2 L's, and it is M. Parilla, P-A-R-R-I-L-L-A, at ParillaLawFirm.com. If you have any questions, if you want a copy of the PowerPoint, if I haven't addressed something fully, please email me. I'll be happy to respond or send you a copy of the PowerPoint. Okay, thank you. My time's up.